All right, so now we are going to talk about ethics, professional ethics. And so we're coming at this from the standpoint of we have our CPA license in a particular state, and we're either in the auditing profession or we're just not in the auditing profession but doing other stuff. So there's definitely a difference, and different types of organizations have different ethical standards depending on what you're doing, whether you're an auditor or just doing something else within the accounting profession. What we're not going to do is talk about ethics overall, and so you're free to look over this first part where they talk about what are ethics, and how you make a decision when you're trying to make an ethical decision. Other courses have certainly dealt with this far more than what we could, and by now you probably have had at least a couple of bites at the ethics apple. But having said that, I would say that if you were raised by fairly ethical parents who have strong core beliefs, hopefully, not always, but hopefully some of that rubs off you and you're able to make good, you have a good ethical value base and can take that knowledge and go forward and make good ethical decisions. But quite frankly, if you were raised by a mother who was, or a father, or both, who were into criminal activity, not to say that you couldn't learn not to do the stuff they do, but I mean, you're coming at this at a severe disadvantage, and so you're going to have a harder time. You don't have that basis upon which to make good ethical decisions. There are always exceptions, I realize. So how do ethics fit into the accounting profession? When you become a CPA, you're required to act in an ethical manner. Just even applying to be a CPA, you have to meet certain standards. Just to even be a CPA, but it's a continuing obligation as well. You cannot lead an unethical life professionally, or really I would say even personally. I mean, it's kind of hard to live a personal life or a professional life that's ethical and then lead kind of a double life of doing unethical things personally. It's kind of hard to bifurcate the two. So when you're a professional, you are held to a higher ethical standard than just an average person, especially as it relates to your dealings within the profession, but it might even affect some of the things you do personally. Why do we need to be ethical in our conduct? When you hold yourself out as being a professional, you're expected to act above and beyond what the general public acts. And you're held to a higher expectation than the general public. And you have to continue that. It's an ongoing obligation professionally. The reason why CPA firms are engaged and paid by companies in issuing these financial statements is because they provide some reasonable assurance to the third-party users that the financial statements are correct. If we're doing unethical things, you know, possibly, let's say we have an appearance of impropriety because we have ownership in the company that we're auditing. Well, that's not just an appearance of impropriety, that's an actual impropriety. And so the general public would question our impartiality if we actually owned a stake in the company that we're auditing. And so this idea that CPAs and CPA firms are held to a higher standard is so that the third-party users can have some confidence that the CPA firm is auditing these statements impartially. Otherwise, if they don't have that belief, then all trust breaks down. So this points out that CPAs are encouraged to conduct themselves at a high level. When you're a CPA, you have several different agencies with varying degrees of rules of conduct. Some of them, quite a few of them overlap, some of them not so much. But the two big ones here are the Code of Professional Conduct, and that could be at the state level and AICPA level. Many times they're pretty parallel in what they say. And then if you are an auditor of a public company, if you are with a firm that audits public companies, then you have another set of rules issued by PCAOB and the SEC. So many different, although, you know, a lot of this stuff is fairly similar, but when you're auditing a public company, you have some additional rules issued by the PCAOB and the SEC. And so the first thing we want to do is look at the purpose and content of the AICPA Code of Professional Conduct. And so it's broken down into 4 parts, and we're going from general to more specific here. The principles are what they call ideal standards of ethical conduct stated in philosophical terms. So it's fairly general, and these principles, while while they are ideals, they're certainly not enforceable because they're just too vague. Next, we have rules of conduct. Here, we're getting more specific with things we can and can't do, and these are enforceable. Now, understand that these rules of conduct are a minimum standard, but as the book points out, it's the bar is raised so high that the actual minimal standards of ethical conduct are are still above what a normal person would be expected as far as their conduct. And then we have interpretations of the rules of conduct. And so, again, these are not enforceable, but they are the CPA's interpretation, and as such, because they are interpreting the rules of conduct, a departure by a professional must be justified. Last but not least, we have ethical rulings. These are past rulings based upon certain ethical issues that have arisen, and so they're not enforceable, but they're certainly they certainly give the CPA some idea of how they should act, because a departure again has to be justified. All right, so the first is these ethical principles. Again, these are ideals. They're not enforceable in and of themselves. But the things they talk about in here are responsibilities, and so says that professionals should exercise sensitive and moral judgments in all their activities. Notice it doesn't say in their professional activities. I think this goes to personal as well, and I'll show you why here in a little bit. Number 2, the public interest. Members should accept the obligation to act in a way that will serve and honor the public. Number 3, integrity. Members should perform all responsibilities with the highest sense of integrity. Objectivity and independence. Members should be objective, independent, and free of conflicts of interest. We'll talk about independence quite a bit here. Due care. Members should observe the profession's standards and strive to improve competence. When it comes down to a lawsuit, what a jury or a judge would do is determine whether or not the member followed professional standards, also known as due care. And another way of looking at this, they would take a reasonable professional and ask what if a reasonable professional would have done what the professional in this case did. If not, then the professional in this case, it would be held that they didn't use the standard of due care, or didn't rise to the standard of due care. Scope and nature of services. A member in public practice should observe the code of professional conduct. True enough. And so here again, these rules of conduct are set at a minimum level of conduct, but again, it's high enough that even the minimum is pretty good. In other words, yeah, you don't want to fall below that minimum level, and actually you may strive for something much more than the minimum level, but even the minimum level is far above what a normal person who's not a practitioner would be required of. We have these international code of ethics. We're not going to go over them. So moving on to the Sarbanes-Oxley Act and the SEC requirements as well as the PCAOB requirements. And one of the things that I want to go back to one thing. Independence. Let's talk about independence. A member of the AICPA is supposed to be independent in mind as well as in appearance. And so, and they have to be both, because even if a CPA is independent in mind, if to outsiders it doesn't look as if they're independent, then the general public loses trust in that CPA or CPA firm. So independence in mind is the state of mind of the practitioner, that they are independent. Independence in appearance is based upon others' interpretation of that independence. And so sometimes when you hear of the phrase appearance of impropriety, you know, something may be proper, but it looks as if it's improper to third parties. So that's what they're talking about here when they're talking about independence in appearance. You can't have an appearance of impropriety going on, because it makes these third parties think you're not independent. All right, going to this. Under, well, we already went over that. Sarbanes-Oxley and the SEC provisions addressing auditor independence. Now here, again, we're dealing with auditors of publicly held companies. So there's some additional rules as far as auditors of publicly held companies. And so what does it mean to be independent under the SEC rules and under Sarbanes-Oxley? And what they've done here is restrict certain types of non-audit services that can be provided to these publicly held companies that the auditor also is auditing. And so not all services provided to an audit client are prohibited. It's only certain types, and there are 9 of them. And so the prohibited services of an audit client by a CPA firm are the following: bookkeeping and other accounting services. If the SEC feels that the auditor, by also doing bookkeeping services for the audit client, is basically auditing their own work. And so they prohibit bookkeeping services. Financial information systems design and implementation. Essentially, the audit firm would be auditing the information system of the audit client that they set up. Appraisal or valuation services, actuarial service, internal audit outsourcing. If the audit company, the audit firm, is performing internal audit for the audit client, again, they're essentially setting up the internal controls, or at least there's the appearance that they are setting up the internal controls of the audit client. And so there's some question as whether or not, if you're doing internal audit service, whether or not when you're giving your opinion on the adequacy of internal control, whether or not you're essentially auditing yourself. Management of human resource functions, being a broker, dealer, or investment advisor, or offering investment banker services, legal and expert services unrelated to the audit, and any other service that the PCAOB determines by regulation is impermissible. So they have, by that 9th one, they have the ability to expand this beyond the other 8. Now, that does not mean the CPA firm is prohibited from doing anything. And so a CPA firm of an audit client could also provide tax services for that audit client. What they can't do is provide tax services for high-level executives of the audit client, and there are some other prohibitions as well. The audit committee. The audit committee must be an independent group, and usually it could be, 3, 5, 7 individuals on this audit committee. These members on this audit committee must be members of the board of directors of the company, and they must be independent. And so you can't have, for instance, you can't have your CEO and chairman of the board on your auditor or on your audit committee, because they're not independent. And so these would have to be what they call outside directors. You also have to certify, the company has to certify that at least one of these independent directors is what they call a financial expert. Now, it doesn't say, what is a financial expert? I don't know. Am I a financial expert? Heck, I don't know. Probably from all my degrees, I am, but, somebody else might debate that. But I suppose if you're a CPA, you're probably considered a financial expert by the SEC. As you can imagine, relationships between the audit firm and the audit client can somewhat be cozy. And so it's not uncommon for members of the audit firm to be offered employment by the audit client. Well, the problem with that is, at least on the surface, it might appear to be an improper relationship once that occurs, because essentially, if you're coming, let's say you're coming to work, you've been offered employment by the audit client, you were the audit lead for the audit of the audit client. Now you've been offered the job of, let's say, CFO or chief accounting officer, whatever. You know, in your new position, what the audit team's going to do, or you possibly could, unless the audit team changes their tactics. And so, to avoid any appearance of impropriety, what the SEC requires is that there be a 1-year cooling off period that must occur before a member of the audit engagement team can accept a key management position at a client. Well, what does it mean to have a 1-year cooling off period? Well, essentially, this person would have to wait 1 year, would have to not be on the audit team for a year before accepting employment. So strategically, how does that work? I have no idea. Usually when you're offered employment and you're a member of the audit team, you're not going to want to wait a year to accept employment, and quite frankly, the audit client doesn't want you to wait a year. So it's a very difficult situation. Now, this cooling off period only refers to certain high-level employment offers by the audit client. So, you know, some lower-level positions, not a problem. Certainly, if you're on the audit team, you could accept one of those positions, lower-level positions within the firm, and that's quite common. On top of this, the SEC, Sarbanes-Oxley, requires the lead and what they call the concurring audit partner. That's the partner who essentially, at the end of an audit, looks over the audit and basically signs off on what was done. So both the lead audit partner and the concurring audit partner have to rotate off the engagement for a particular audit client after a period of 5 years. Well, that's pretty stringent. The question is, why do they do this? And I'm not sure what the rationale is behind this, but I suppose that the SEC and Congress, who was responsible for Sarbanes-Oxley, thought that by having a continuous lead and concurring audit partner, that things might get too cozy and independence may break down. So I guess that's why. I'm not totally sure. Ownership interests. And so question is, if you own stock in an audit client, are you independent? Well, what if a family member owns stock? What if your wife owns stock? What happens if you have a mutual fund that owns stock in an audit client? So a lot of this stuff deals with that. And so the SEC rules prohibit ownership in audit clients by those persons who can influence the audit. Well, who would that be? Well, certainly members of the engagement team, those in a position to influence the audit engagement in the firm chain of command, partners and managers who provide more than 10 hours of non-audit services to the client, and then partners in the office of the partner primarily responsible for the audit engagement. And so this concerns, and for all those, it's not only personal ownership, but also family ownership. So there's a family attribute rule, basically. If your wife owns stock in a the company that you're auditing, that's prohibited. It's as if you own the stock. So you have to get off the audit team and not have any involvement. We're going to skip over shopping for accounting principles and talk about engagement and payment of audit fees by management. So the question is, when the audit firm is doing these audit engagements, they're being paid by the audit, the company subject to the audit. So the question is, can the CPA firm doing the audit truly be independent? So, you know, that's a problem. That's a question that arises all the time. Not really saying there's a good answer for that, but it does come up, that how independent can you be if you're being paid by the audit client? Here's a ethical quandary. How independent can you be if your audit client is 75%, or better yet, 95% of your revenues? I mean, what happens if they threaten to fire you and go hire another firm, and these engagements are fairly competitive, so competitive it's not unusual for these companies to make bids for engagement, even on a yearly basis sometimes. Well, you know, if your revenue is 95% by this company, then you really have to wonder if that audit firm is independent. All right, so next thing is independence, rule of conduct, and interpretation. And so under the rules of conduct here, it says a member in public practice shall be independent in the performance of professional services as required by standards promulgated by bodies designated by the council. Well, again, we're back in the code of conduct, the AICPA code. So this is just kind of a general thing. And so it goes to talk about financial interests here. And so interpretations of Rule 101 prohibit covered members from owning any direct investment in audit clients. So it deals with the members themselves, and then looks also at indirect financial interests as well as financial interests. And so we know, I think we can pretty much figure out what a direct financial interest is when we, a member of the AICPA, own stock in a company that we're providing services to. What about indirect financial interest? So they talk about an indirect financial interest existing when there is a close but not a direct ownership relationship between the auditor and the client. And so the example they give is where the, let's say the partner on an audit of a particular company owns shares in a mutual fund, And so what it gets down to, whether or not that's an indirect financial interest, depends on how much of that mutual fund is invested in that particular company. If it's pretty substantial, meaning material, then that's an indirect financial interest, and that person is prohibited from having either a direct or indirect material financial interest in that company. If it's immaterial, if the mutual fund owns an immaterial amount when compared to the overall ownership, then it's not considered an indirect financial interest, and therefore is not prohibited. Here's some related financial interest issues. Former practitioners in a firm. It permits former partners or shareholders who left the firm, usually due to retirement or sale, to have relationships with clients of the firm of that type without affecting the firm's independence. The only way a former practitioner could possibly have a violation of this rule is if they hold themselves as being associated with the firm still. Usually not an issue, but sometimes it might be. Loans between a CPA firm and an audit client are prohibited generally. But what happens if your audit client is a pretty well-known bank in the community? Well, in that case, a practitioner is not prohibited from representing an audit client where these things are such things as automobile loans, loans that are fully collateralized by cash deposits, unpaid credit card balances less than $10,000 in total, and mortgages at a financial institution. What about financial interests and employment of immediate and close family members? And so if you have a spouse who owns a financial interest in an audit client, that's as if you own it. What about other mother and father? What if they own an interest in an audit client? Well, it kind of depends on whether or not it's a material amount. So you would have to look at materiality. If it's not a material amount that they own, it's not considered an issue. If it is a material amount, then yeah, it's an issue. As far as a family member being an employee in an audit client, kind of depends on where they are. If they have the ability to make management decisions concerning this company, then probably there's a conflict, and you can't. The audit firm could not audit the client firm. Jointly held investments with a client, and so basically we're talking about the audit firm or some of its partners having an interest, financial interest in company B, and the audit client also having a financial interest in company B as well. That looks like a jointly held, closely held investment with the client. They both have a common interest. So for that reason, such jointly held investments are prohibited. Unless, you know, being a member of the audit firm, unless the question is whether or not that member of the audit firm can be a director of the audit client. Well, the general answer is no, unless it's like an honorary membership or something like that, where they don't actually vote on anything. Otherwise, that would be a conflict if they could vote. And then certainly you don't want your members of the audit team or the audit firm being officers of the company they're auditing, and don't want them being involved in management decisions as well. Note in this same section that where a firm has a lawsuit against the CPA firm involving you know, certain issues, question is whether or not the CPA firm can remain objective, and so it's a big question. Usually at that point their objective or objectivity is somewhat clouded, and so this includes existing lawsuits as well as the audit client's intent to start a lawsuit between the CPA firm and the audit client. And so if you have an existing lawsuit or a threat of lawsuit, it's a violation of this Rule 101. Bookkeeping and other services. The AICPA code permits a CPA firm to do both bookkeeping and auditing for a private company audit client, although you would have to question the objectivity of the audit firm auditing essentially its bookkeeping. They're basically auditing themselves. There are some conditions that the client must meet in order for the audit firm to do both the bookkeeping and the audit. And it's essentially boils down to the fact that the audit client must accept full responsibility for the financial statements, and the CPA must not assume the role of employee or of management conducting operations of the enterprise. And then the CPA must still conform to auditing standards, even though they're the ones doing the bookkeeping. And so that's really kind of hard to do. I don't know how audit firms really do that. If it was my audit firm, I wouldn't do bookkeeping services for a firm or a company that I also audit. The SEC and the AICP rules do not allow audit firms to provide bookkeeping services for public company audit clients. Makes total sense. What about unpaid fees? Says that under Rule 101, independence is considered impaired if billed or unbilled fees remain unpaid for professional services provided more than 1 year before the date of the report. Such unpaid fees are considered a loan from the auditor to the client and therefore are a violation of Rule 101. So what they're talking about is fees owed prior to a certain engagement for a particular year. If there's unpaid fees that exist, then it looks like a loan, especially if it's for professional services provided more than 1 year before the date of the report. My gosh, you've gone over a year without being paid? That's crazy. Now, this rule doesn't apply if the professional fees are a part of a bankruptcy. But who wants to have a audit client that's in bankruptcy? All right, and then other rules that they have. 102 deals with integrity and objectivity. Number 201 deals with general standards. 202, compliance with standards. 203, audit accounting principles. And then 301, confidential client information. Talk about a couple of things here. Certainly, confidentiality. Certainly, you have to keep information concerning your audit client confidential. You find out a lot of stuff, compensation of certain employees and executives. You're supposed to keep that information confidential. You might come into confidential information concerning mergers and acquisitions. You have to keep that confidential. You can't spread that around. There are exceptions to this, such as when you're subpoenaed, within either a regulatory type of forum or some sort of court. If you're subpoenaed, you have to provide information even if it is confidential. And certainly if you have a peer review, if you recall we talked about that last chapter, by another CPA firm, you have to provide all information including confidential. And then a response to an ethics division complaint, you have to provide any information regardless of whether or not it's confidential. Contingent fees. You can't, it's kind of hard to maintain objectivity, or at least the appearance of objectivity, if you're charging based upon a certain outcome, is what this boils down to. In other words, let's say we agree to provide tax services to a company, and the size of our fee is based upon the amount of taxes that we save them. Well, the bottom line is the more we save them, the more we get paid. So at least the appearance of objectivity is somewhat clouded. Here, this next one, acts discreditable, is kind of a catch-all, and this is where your personal life can catch up with you. That little DUI you got driving home from the bar, you would have to report that not only to, well, especially your state board of accountancy, but if you're a member of AICPA, you'd have to report it there as well. And so this is where, again, things you do in private could all of a sudden come up. If you have a DUI, and that's just one example, you're going to have to report that to your state board and the AICPA. And they're going to open up an inquiry on you as to your soundness, your fitness to continue practicing as a CPA. So again, it's really kind of hard to bifurcate living an ethical professional life from living what might be considered an unethical personal life. So you kind of have to be ethical in all facets of your life in order to make sure you don't run afoul of the State Board of Accountancy and the AICPA. What about, what if the client doesn't pay you? Can you keep their files? And under this catch-all rule, they've ruled that withholding a client's files for non-payment is considered an act discreditable. So it's kind of a catch-all. It can really come back to bite you if you commit any kind of crime. Unless it's like a parking ticket, you've got to report it. Got to be very careful. Advertisements and any forms of solicitations, you got to be really careful there. There used to be a prohibition against all advertisements by CPA firms, and certainly we don't have that. But I think the main thing there is you want to be tasteful. If you know that a certain client is using another CPA firm, question is whether or not you can go poaching and try to lure them away. So you have to be very, very careful how you do that. And I would say that probably the best thing to do is make the potential client be the one initiating such contact, not you. Commissions and referral fees. And so they go through Rule 503, talks about prohibited commissions. And so says a member in public practice shall not for a commission recommend or refer to a client any product or service, or for a commission recommend or refer any product or service to be supplied by a client, or receive a commission when the member or the member's firm also permits or performs for that client an audit or review of a financial statement, compilation, or an examination of prospective financial information. Bottom line is, if you refer a client to someone else, let's say an attorney, that attorney cannot pay you a commission. What about the form of organization? Essentially what this says is it's pretty wide open. It says as long as the state in which you practice allows it, the form of the organization, whether it's sole proprietorship, general partnership, corporation, LLC, LLP, all of those are acceptable as long as the state that you're practicing in allows it. As far as the name is concerned, I think as long as the name is not misleading, any name, including something other than the names of the partners, is acceptable. So, question is it misleading? If not, then it's it's certainly okay. There's some rules there concerning ownership of CPA firms by non-CPAs. I'm not sure why you would have that. I would think that that would be a big problem. And number 8, describe the enforcement mechanisms for CPA conduct. And under this AICPA, you've got the Professional Ethics Division that can open an inquiry on you. State Board of Accountancy has their own enforcement people, and then PCAOB has an enforcement division. And so if you, back to my example, commit even a Class C misdemeanor or a low-level felony, you're definitely going to have the State Board of Accountancy opening up an inquiry on you. If you're a member of the AICPA, they're going to open up an inquiry on you as well. And then if you are in a firm that audits publicly held companies, you're going to have an inquiry opened up there by the PCAOB as well. So triple whammy, lawyer up. The end.